Hello and welcome to Legal Basics with Cyro Law Global. My name is Sian. On this channel, we help you to demystify complicated legal concepts. Today, we are going to talk about a sale agreement. At whatever point in our lives, we may need to acquire or to sell property. Now, it is very advisable that when you start this journey, whether as a buyer or a seller, you start it with a legal expert. This ensures that you do not get duped by unscrupulous sellers and buyers. It also ensures that you do your correct due diligence. It also makes the process much easier and much faster, and ensures that at the end of it you have the correct documentation. So what is it that you should look out for in a sale agreement? Number one, your sale agreement must be dated. If you and your seller are present on the day that you make your sale agreement, then in that case, you will need to date your sale agreement the day that you both signed. However, sometimes the buyer and the seller are in different places or in different countries, and for some reason, they are not able to sign on the same date. When this happens, it is advisable then that you date the agreement on the date that the last person has signed it. Why do you date it on the day that the last person has signed it? Well, it is because the date on the sale agreement is the day that all the parties become bound. Remember that if an agreement has been signed by one person and not signed by the other, then it is not binding because it is not complete. A contract becomes complete when all the parties sign it. So if several people are parties to an agreement, then you're going to date it on the day that the last person has signed. The date of the agreement is also important because if you're going to stamp the agreement, then the government valuer is going to consider the date to know how much stamp duty to charge you. Remember, when an agreement goes beyond 30 days, then it starts to attract a penalty in terms of stamp duty. Secondly, you need to look at the parties. Sometimes the person you negotiate with, or the person who is a broker, or the person that helps you to get a plot, or the person that helps you to negotiate is not really the person that sells to you. So you need first of all to know for sure who is the property registered in, and then you need to know for sure how you want to acquire it. Do you want to acquire it as a person? Do you want to acquire it as a couple? Do you want to acquire it as a group? Now, for example, if 3 people own a company, they could acquire property in their 3 joint names, which means the property will be owned by them, or they could acquire it in the name of the company. If you're buying from a seller who is a registered company, you need to also get it right. You need to understand that Sian and Sian Limited are 2 different legal people. And if you have to have an agreement that ties them to a legal obligation, then you need to ensure that you have the correct name of the party. In the event that the person that you buy from is not the person that is registered on the property, you also need to have gone through the agreement that led to this person owning the property so that you're not duped. Now, on the parties section, you need to describe the parties, that is their names. If you're dealing with a natural person, you need to capture their ID number and their PO box address. If you're dealing with a company, you need to look into the company's certificate of incorporation. This will give you the company registration number. So the third thing to look out for is the description of the property. So if you're buying property that has a ready title, you're going to capture all the description of the property in the title. The land reference number, the title number, the size of the property. However, sometimes people buy property in places that have not been adjudicated, or sometimes they buy property that is part of a bigger property that is yet to be subdivided. In that event, ensure that you describe the property as much as possible. For example, let's say that you're getting a property that is 1/4 of an acre in a title that is yet to be subdivided, but you are getting the quarter just right next to the river. it is actually important for you to describe in your agreement for sale that you're buying the property at the very corner, just right next to the river, with a beacon and a baobab tree. So how does this protect you? Because sometimes a seller will enter into different agreements for sale with different buyers. So this ensures that once the titles are out, you get the exact piece that you had negotiated. Okay? So, fourthly, you need to have a clause on the purchase price. How much have you agreed? Sometimes before you get to the process of buying property, there's a lot of negotiation. You meet a broker, they tell you no, the land is going for 5 million. You meet the seller says no problem, I can take 3.5, and you have a lot of negotiations in between. It is extremely important for you to capture what the final purchase price is. After that is captured, you need to capture how much deposit has already been paid. If deposit has already been paid, ensure that in the sale agreement, the seller acknowledges that they have received a certain amount of deposit. Now, as far as deposit goes, it is advisable that you do not pay a very big deposit until a substantive part of the seller's obligations have been fulfilled. Now, when a deposit has been paid, there should be also a clause that specifies how much balance is payable. Now, especially in situations where different people are selling, or you're buying from a family, or you're buying from a company, or you're buying from a couple, you never really know what the seller's agreement is with regards to money. So that you're safer as a buyer, ensure that the agreement says exactly which account the balance will be paid to. As a seller, ensure that the agreement says exactly which date the balance needs to have been paid. Now, also your agreement should capture the date of completion. This is the date at which both the seller and the buyer should have met their end of the deal. So for this buyer, most of the time, all they need to do is get money. So for the buyer, most of the time, the end of the deal is to just pay the balance. But for the seller, sometimes it's a very long process. If, for example, your seller is selling agricultural property, then you might need to go and get a land control board consent. If your seller is married, they have to get a consent from their spouse that says that their spouse agrees to the sale. Sometimes your seller has to go and maybe remove a caution or a caveat that has been registered against the property. So having this date, having a completion date captured on the agreement, it helps both parties to gauge whether the buyer and the seller have met their obligation under the sale agreement. The other thing that you need to look out for is the applicable law. So if both parties are from the same country, it might not be very important because it is obvious that the property and the people are in the same country, so the law of that country will apply. However, sometimes the seller and the buyer are buying property that is based in a different country. Sometimes the seller is in one country and the buyer is in another country. So it is important to note on your agreement for sale exactly which law is applicable. Then it is important to note on the agreement how notices will be served. If, for example, the completion date is already here and for some reason either the buyer is unable to get the purchase price or the seller is unable to complete whatever part of the transaction, how are they going to handle this? So it is very important to have timelines. For example, if the completion date expires on such and such a date, then the seller or the buyer will inform the other. They're going to give them another 21-day notice or 2 months notice, depending with what you agree. Now, once you have all this, it is important to have a warranty clause. A warranty clause is the clause where the seller assures the buyer that they're going to pass good title. So good title means that the property is registered correctly in the name of the seller. It means that there is no pending litigation, there is no fight, there is no court case. It means that the land is not a road reserve, it's not government property. Now, the warranty clause should always outlive the agreement. Outliving the agreement means that even once the conveyancing process is done, if something happens and the buyer gets to know that maybe for some reason this property will be acquired or the government will come for it, like what is happening in Gong Forest at this time, then the seller will indemnify the buyer. Now, lastly, you need to really pay attention to the execution. Execution means signing. On the signing part, ensure that the correct people are signing. If the buyer or the seller is a company, ensure that the people that sign are the directors or the director and the company secretary on the date that the agreement was entered. If, for example, an agreement is signed by outgoing directors and on the date of the agreement, the directors were no longer in office, that alone will make the agreement to be a nullity. Now, if two people, for example, a couple, are acquiring property, ensure that both of them sign, because if both of them do not sign, again, the agreement becomes null and void. So you need to really pay attention to the execution clause and ensure that in that clause, the correct parties sign. I hope that this has been very helpful to you. See you next time on this channel. Sanitize, keep social distance, and stay safe. Bye-bye.